thank you for joining us today. We have an excellent panel to discuss some really pressing issues in the evolving role of state regulatory and enforcement agencies at the moment. I am Adam Hollander. I am here to help facilitate discussion from the law firm of Slarsky LLC. For those of you not familiar with us, we provide representation in a range of disputes-related matters, litigation, arbitrations, and otherwise. I have a particular background in plaintiff side securities and corporate governance work, as well as other plaintiffs' work and some work on the defendant side of the V as well, and thinking about the role of regulation and enforcement and the ways that it touches my clients and the issues that come up in our cases is always at the front of my mind. We are very fortunate today to have an excellent panel here to discuss both some shifting priorities lately, and in particular, the role that state agencies play in regulation and enforcement across a variety of areas, whether that's securities or consumer areas, and really across industries as well. So I'm very excited to hear what our panelists have to say. First, we are very fortunate to have Tom Miller. Tom is the former Attorney General of Iowa for a total of 10 terms. He's the longest serving state attorney general in U.S. history. And under Tom's direction, his office played a leading role in coordinated efforts by state attorneys general to hold corporations accountable in areas such as big tobacco and opioid manufacturers, as well as antitrust enforcement, mortgage lending industry, and many, many others. So Tom, thank you for joining us. Second, we have Dan Seligman. Dan is a lawyer and a certified fraud examiner. He is a former journalist with extensive experience performing due diligence and fact-finding investigations for lawyers, trade associations, government agencies, and other clients. And Dan has served as an arbitrator for FINRA and the National Futures Association. And last, but certainly not least, we have Vin DiCiani. Vin is the founder and president of Affiliated Monitors. He provides independent monitoring and compliance consulting, working with both government agencies and with regulated companies. And in their respective fields and roles, each of our panelists has some key insight into the work of state regulators, particularly at a time of changing federal enforcement priorities. To set the stage quickly before we jump into the meat of it, there have been many publicly announced shifts in enforcement and regulatory priorities under the current presidential administration, so really since January of 2025. Among other things, in May of 2025, the Department of Justice issued a memo warning about overbroad and unchecked corporate and white-collar enforcement, and instructing prosecutors to avoid overreach, this is the words of the memo, that punishes risk-taking and hinders innovation. So the focus under that memo is to prosecute individuals rather than corporations, to emphasize the rewards of corporate cooperation and self-disclosure, and that monitorships should be used sparingly and in narrowly tailored ways, more narrowly tailored than perhaps in the past. In February of 2025, President Trump issued an executive order pausing Department of Justice enforcement under the Foreign Corrupt Practices Act, the FCPA, shifting the focus to trade and customs fraud, including tariff evasion. And there is a new memo in June of 2025 ending that pause, but containing guidelines really cabining in the enforcement of the FCPA. At the SEC, there has been very publicly announced a back to basics enforcement approach. In 2025, the SEC had the lowest amount of monetary settlements in over a decade, just over $800 million for the year. Obviously, a big number, but not as large as historically, as well as record low disgorgement by the SEC. And we also just had on April 7th the announcement of the National Fraud Enforcement Division to coordinate anti-fraud efforts. And there was an MOU, a Memorandum of Understanding, about coordination and collaboration between the SEC and the CFTC on digital assets in the crypto space. And that occurs when there has been significant staff cuts and voluntary departures of enforcement staff. So we have a consolidation of certain regulatory and enforcement resources, while at the same time the staffs of those agencies is being reduced. And at the same time, there are, as perhaps always, new and emerging vulnerabilities that consumers and investors face. And those are found in everything from the role private equity has come to play in healthcare and government contracts, really the continued explosion of crypto markets. And by that, I include issuers of various digital assets, as well as the market infrastructure that continues to grow around those asset classes. We have new challenges in cybersecurity and AI, including data privacy issues, as well as the emergence of prediction markets and questions maybe about how prediction markets function, how they ought to be regulated, and the safeguards that ought to be in place to protect consumers who are in those markets, who are betting on real world events and the likelihood of them happening. So the main question, and what I want to talk about with our panel today, is what does this all mean right now for state level enforcement and regulation in areas like antitrust, consumer, investor protection, false claims, and healthcare? What are the risks and what are the opportunities for state level regulatory and enforcement agencies right now? So, Tom, I'd love to start by hearing from you. In your 40 plus years as the Iowa Attorney General, how did you view the role of your office in relation to federal enforcement agencies and regulators? And did that change between when you first took office and just a couple of years ago when your last term ended?
Well, the relationship depended, at least in part, on the administration, and particularly whether they were in what I call the wide mainstream or whether they weren't. Typically, if there was a Democratic president, the consumer and antitrust would be in what I would characterize as center left. If a Republican administration, it would be center right. And there'd be a fair amount of common principles and common views, that it would be a sort of a cooperative relationship and a very productive one, and would reflect the idea that the AGs have been and continue to be the most bipartisan group of elected officials in the country, despite all the lawsuits. They're bipartisan because of what you're talking about, multi-states, where you'd have Democrats and Republicans working together on antitrust cases or mortgage foreclosure and so on. But sometimes, particularly in parts of the Reagan administration, they were outside what I would consider mainstream. And we would engage, we would fight, I think, somewhat respectfully. We fought over the definition of deception at the FTC with the Reagan administration. And they had a set of enforcement of principles for antitrust. We had a set. So you have that relationship. And then at times, we had what I would call just an exceptional relationship where we worked really closely with the federal people. And two major examples of that was the Microsoft antitrust case. Joel Klein and I and others worked together extremely closely, David Boyce as well. It was one really joint effort between the states and the feds, and it was sort of the best kind of relationship. It was equaled really in the mortgage foreclosure area, where we worked with Tom Pirelli at the Department of Justice in a very cooperative way with a lot of respect. So it varies depending on the relationship.
Just a quick follow-up before we move on here. Are there any factors that, to your mind, are responsible for the ability of state attorney general's offices from across the country to work together on issues that ostensibly matter to their constituents? In other words, despite whether it's a Democratic administration or Republican administration in any particular state or on the federal level, what is it that enables the state AGs to work in a coordinated fashion on behalf of their constituents?
Yeah, there's a number of factors, one of which is that there's this tradition of doing it, a long, rich tradition of doing it together. And another factor is that the assistant attorney generals work together a lot and have a great relationship. Another factor is that In some of the big cases, an individual state, even New York or California, doesn't have the individual resources. We need to partner up. And part of it is that in consumer and antitrust, there's a big effect on our constituents. And we've been able to focus on that rather than the political or ideology part of it when working together. It's a remarkable story in today's world where, and continuing on to today, and particularly in the opioid situation recently, states have worked really closely together. Typically, there'll be a steering committee with equal number of Democrats and Republicans and have produced extraordinary results, I believe, on that. The mortgage foreclosure, an example, and the tobacco case being the ultimate example. The tobacco case had 49 states ended up signing on to that out of 50. I draw the comparison to the U.S. Senate. If there was a controversial, divisive issue and you had 98 senators agreeing on it, it wouldn't happen. But it happened in the AG world.
Vin, I'd love to talk about your monitoring work, and in particular, curious to hear how do you interact with state agencies in the work that you do, and how have you seen the role of monitoring change in the last 2 to 3 years, whether that's areas of concern or particular industries or types of issues that you've seen more of?
Thanks, Adam, and it's a pleasure to be here, and it's an honor to be on a panel with Tom Miller, let me tell you. So, yeah, monitoring, I've been doing it for 22 years now, and there have been some changes. And I think we first have to talk about the federal side of things, and then we'll talk about the state AG side, as you sort of have intimated. There are some changes on the federal side, but the way I best can describe it is bad behavior is bad behavior, and there's got to be consequences, right? And so, well, your priority may not be FCPA by DOJ. They are still going after fraud and false claims and antitrust violations and those kinds of things. That has not decreased, and in fact, I think it's picking up over time. We'll talk a little bit more about that in a minute. So I think on the DOJ side, while there's been less focus and priority on FCPA, there's other things that remain priorities. And so there's very little change there. Perhaps the focus on using monitors has been decreased in some aspects of DOJ. However, the antitrust division is still using monitors on a regular basis, particularly with divestitures and competition issues. Other federal agencies are continuing to use monitors. The OIG for HHS, which is the Medicare system, still uses monitors called IROs, independent review organizations, regularly. That has not decreased and perhaps has picked up under this current administration. So healthcare fraud is still a major focus, and the use of monitors remains prevalent. The FTC is still using monitors on some of its matters on consumer protection, antitrust, and those types of areas. So federal side, it's continuing, perhaps no longer on the FCPA side with the great frequency that it had. On the state side now, state regulators, particularly through attorneys general offices, are starting to use monitoring with more frequency. You know, Tom has talked a little bit about the multi-state matters, the opioids, tobacco, and now the Live Nation matter. But for individual states, they are starting to apply monitoring in a variety of circumstances that they hadn't before. So I see it as an expansion of the use of monitoring. And I'll give you a couple of examples. Healthcare fraud in the Medicaid space, very active right now, and using monitors as sort of a probationary remedy, is being used not for the worst of the worst actors, but for those that the agency decides are remediable, right? So that's who you work with, helping them perhaps with their compliance programs and learning what regulations are and how to use them and apply them in their practice. State antitrust actions have really picked up, and that's just increasing. And Tom could talk about that with some more detail, but it's an area where state attorneys general office starting to use independent monitoring as a probationary remedy. And then the other area that I think is really expanding is the notion of hospital mergers and situations where private equity is getting involved in purchasing, for example, a rural hospital in a community where the hospital is very important. And if that hospital closes, then people may have to go a long way to see a doctor, go to an emergency room, or what have you. These acquisitions by private equity of these types of situations, state AG's offices are now putting more scrutiny on those kinds of actions and using monitors to watch the conditions that are put in place when the approval of such an acquisition occurs. And so we're doing a lot of that type of monitoring. So there's a change afoot, Adam, that I think is very positive. And in terms of the world of monitoring, I'm seeing it expanding. It's not contracting.
Is the nature of the monitoring work any different when you are brought in by a state agency versus by the feds? Let's say it's the same area. Let's say we're looking at antitrust, and in a case where you might have expected the FTC to be driving things forward, if it's states right now, is the nature of your work any different?
It can be because states, particularly when they're working individually, have a lot of leeway in crafting the terms of a settlement. They can put affirmative types of actions as well as things that the company cannot do into an agreement. So they can be very creative. And we're seeing that more and more. Where I'm seeing it most currently is in the Medicaid fraud arena. The Massachusetts Medicaid Fraud Control Unit, in particular, is very proactive in using monitors to work with entities that really need to be fixed. Again, they're getting rid of the bad ones as they typically do, but the ones that can be fixed, they're putting in monitors as part of a settlement agreement or an administrative agreement. That's a change. And when they're doing that, they can craft the language and what needs to be looked at in a little different way than perhaps the OIG would be, because the OIG might be focused only on dollars and how dollars are being spent and whether or not there's sufficient backup for services provided. AG's offices can look at lots of other things like safety, resident care in a nursing home, and that kind of stuff. So it's more individualized in the states, Adam, than it might be on the federal side.
So, Dan, similarly in your work, what are the challenges that you've seen as an investigator in the current environment? I know you have an interest in the regulation of commodities and derivatives. What's different about some of the new and emerging markets in those areas?
Thanks, Adam, for having me, and thanks for the question. So I think I would start out talking about this thing called prediction markets, which are a relatively new development that has just exploded in terms of dollar value, just exploded in size. And there's a couple things that make them, I think, challenging for regulators at both the federal and the state level. First, as you've alluded, there's a somewhat diminished enforcement capacity at some of the key agencies, specifically the Commodity Futures Trading Commission. How serious is this? I think we'll find out. Let's have this conversation 2 years from now and see how robust the CFTC has been in enforcing its statute. But the third is just that when you're talking about prediction markets, you're talking about a significant amount of legal and regulatory uncertainty. So a few words of background for those of the viewers who might not have followed the development of prediction markets. They're basically an electronic platform where people can bet on the outcome of certain real world events called event contracts. A few examples, you can bet on election results, like who will, for example, win the Democratic primary in California? Will the Federal Reserve lower interest rates and how by much? Even will Donald Trump publicly insult someone? Pick a date, let's say on April 21st, 2026, and who will it be? More serious bets on will a certain city in the Ukraine change hands on a certain date? How many measles cases will the US see by the end of the year? And then lastly, and not least, sporting events. And they're not just binary, who's going to win a game, but what's the margin of victory or defeat? How many points will a certain player score on a certain date? And two of the companies that are in this space, Polymarket, which describes itself as the world's largest prediction market, and Kalshi have been in the news in part because of the tremendous amount of volume of transactions. In February 2026, for example, Kalshi reportedly traded 1 billion related to the Super Bowl. So the amounts of money trading hands is quite phenomenal. And proponents of these markets say they're regulated exclusively by the Commodity Futures Trading Commission because they're swaps, and they meet the definition of a swap under the Dodd-Frank Act of 2010. That's a change in position from the Biden era, but it's being asserted very forcefully by the CFTC. And when it comes to sports betting, there's another layer of complexity and uncertainty for both federal and state regulators, which is you have states asserting that the event contracts are nothing more than gambling, and that is either prohibited by or regulated by the states. And we're seeing litigation now in New Jersey, Nevada, Arizona, other states, both at the federal level, and there's some appeals going on. Arizona made news a few weeks ago by filing a state criminal charge against Kalshi, alleging that Kalshi had been running an illegal gambling operation within the state boundaries. Eventually, I think the U.S. is going to have to, the Supreme Court rather, is going to have to resolve these issues. But meanwhile, I think it's fair to say that there's a good deal of questions out there about who's protecting retail consumers and what the enforcement mechanisms are to keep the markets honest.
So let me jump off from that question right there. Tom, when you were doing your work as the Iowa Attorney General, and I'll assume that consumer protection was one of the key areas that you considered your office to play a very important role in. Walk us through a little bit of how and why your office might initially start to take a closer look at a particular industry or a particular area where consumers might be vulnerable. And then how did you decide what role does this office play in consumer protection in this area?
Yeah, well, you're right about me liking consumer protection. Some people in the office said that the Consumer Protection Division was my baby, and there's some truth to that. It was a huge priority for me. And didn't neglect the criminal law by any means, of course, but consumer was something I really enjoyed. First of all, you need to know that there's just this wealth of consumer law experts in the AG's offices, and that's in Democrats and Republican offices. And they have a real network. Their biggest network probably is the consumer chiefs, the head of consumer protection in the various offices. So there's just this wealth of coordination and knowledge, watching it all the time. And they helped us immensely. But in the end, it would be the AGs that would decide the major multi-states, whether to go ahead or not. And the factors always I would consider would be first and foremost, what's the overall effect on the consumers if this is an illegal action? The second consideration was, what's the likelihood of us winning? Even if there was great loss and the chances of winning were pretty slim, that argues against that as a major priority. And the third consideration was the conduct egregious? And so some things would just jump right out at you. The mortgage situation jumped right out at us. There was just so much harm and activity and press on that. The press does have some effect on selection of major consumer cases. That's not lost on people. And it's sort of a dialogue between the AGs and the consumer chiefs and consumer lawyers. And I consider it a wonderful mix and was proud to be part of it and indeed one of the leaders of it.
Vin, in your monitoring work, have you at times been involved in matters that several state AG offices are involved in together, or has your work in some way helped, I don't want to say bridge gaps, because it's not that there's necessarily any difference of opinion, but in terms of having broad impact geographically, has your work been replicable or are you brought in multi-state matters?
Yeah, it's an interesting question. Some of the multi-state matters like tobacco did not have a monitor, right? I think they have thought about that long and hard if they had to do it again. But the kinds of things that we're getting involved in are companies that work across states. And so we're involved in one particular matter with a company that has offices around the country. And the AG's offices in each of those states that the company's working in are getting complaints. And then there's one lead state that is taking all those complaints and has brought an action against the company. And so in those types of cases, and Tom, I'm sure you've seen this, it's a feeder. They're feeding information and they're also getting the results of the monitoring work that we're doing to see how the company's doing. The company was allowed to stay in business, had to make some affirmative changes, put a compliance program, compliance officer in place. And so now I think the states that the company's working in are getting the benefit of the monitoring because the company's now a better company. The effort by the lead state was to change the behavior of this company, and it has done that. And I'm going to take credit for it. As the monitor, we really worked with that company to put a good compliance program in and find a good compliance officer, and they're making those changes. That's a benefit that the states are recognizing. So it comes in a lot of different ways. I wanted to point out one more thing, Adam, that Tom mentioned, and that's the press, or maybe you mentioned it. What's happening nowadays is there are a lot of eyes on everything, every company, every event. Everybody has cell phones. So there's a lot more scrutiny on companies and individuals in their workplaces and outside of their workplaces that affect their workplace. That really is having an impact on consumer matters, antitrust matters, the Live Nation complaints about getting tickets to Taylor Swift. All of those kinds of things make a big difference. So it's not just that these government agencies are taking stuff on, they learn about it through consumer complaints. And so that changed the landscape for the kinds of sources of information that AG's offices and the federal agencies as well are getting. Tom, I don't know if you wanted to comment on that, because I think it's important, right? The source of this information, how it's coming about nowadays.
It is. And like you say, there's just so much more information than ever before. But I've always thought that the press didn't have a lot of influence on the multi-states, that some of them were just so obvious that we should do. The mortgage case, for instance. Yeah, we're able to get a lot more information than before, and that can be helpful. It also can bog you down as well.
Well, so Dan, I'd love to get your perspective here as an investigator, as a former journalist. I would imagine sometimes you're brought in by an agency or by a company to do some sort of investigation, some sort of factual digging. Sometimes maybe you start out with a thesis yourself and see what you can develop. Certainly as a journalist, I would imagine that was your role. How do you think about what Vin was just saying, what Tom has been saying about the role of journalists or kind of citizen complaints in drawing attention to a particular area? And then where do you go from there as you're building an investigation and focusing on areas where you think there is some particular vulnerability or some particular harm occurring? How do you fill that role, and how does it operate on a local level or a state level as opposed to a federal level?
Wow, good questions. I'm not sure there's any significant difference between the state and the federal level in
Sure.
terms of the press. My own role has been to work in the background, work quietly. Sure, I've been called in sometimes when there's articles in the press that have triggered some concern, and I've been retained to investigate the allegations. But I don't know that it's really affected my work. It may have prompted me to get the client, but I sort of like toiling in, I would call it well-deserved obscurity in terms of my own role. But coming back to some of the federal issues that we've been talking about, and coming back for a minute to prediction markets, I think one of the things that's interesting to me about these markets, and I've alluded to the dollar value and the legal and regulatory uncertainty, but one of the things that's happened is the press has picked up on people allegedly gaming the system and making money off of things like when the bombing will start in Iran and when it'll stop, suggesting, I don't know whether this is true or not, but suggesting that there are leaks within the administration or leaks elsewhere. And so I think in this case, whether the stories are true or not, they're going to propel some of the federal agencies to take a closer look at insider trading in these markets. That's my sense. I welcome Tom and Vin's reaction as well. But I think this is one of those situations where national stories are going to prompt a closer review of these markets.
Yeah, and I'd love to hear what all three of you have to say. I'll tack a question onto that or frame it a little bit, particularly when we think about these prediction markets and the way that they're emerging. Is there something different about them that warrants a different approach to consumer protection or regulation and enforcement? And whether it's a gap in enforcement otherwise, or whether it's the ease of accessing certain platforms, is there anything different that consumers are facing right now with regard to prediction markets that says to any of you, we need some different approach or some stronger safeguards? Or is this just a different flavor of the same type of vulnerabilities and potential abuses that you've seen time and again for decades?
If I can just jump in here, I think there's two parts to it. It's the sports predictions, the sports gambling, and everything else. And Dan, you've mentioned it a couple of times, I'm a states' rights guy to some extent, not nearly as much as others, but I'm a real strong states' interest person. And it seems to me that the states have gone through this elaborate and laborsome effort to regulate sports gambling and also tax it for tax interest. How can it be that someone else can come up and duplicate it without going through any of that, without any authority? Obviously, they have some arguments to be made, but in terms of public policy, it seems to me that they should have to go through the same process, and that's the state's interest. And on the other side, I think we need to sort of watch what happens, the non-sports gambling, that is. In particular, if they try and hook people through various means, which are all very possible. And I think that's one of the real problems of this gambling industry right now, that they're trying to hook people into gambling more and more, much the same as Meta did in its platform, some of the same sort of tricks. So I think there's a lot to watch. But Dan, what do you think?
Well, I think the US Supreme Court decision is likely down the road on this. There was a recent Third Circuit decision which basically ruled otherwise, Tom. So the legal issues have been put out there, and I think we'll just have to watch how different courts come down. I mean, you've articulated the state point of view very well. And the proponents of the prediction markets will say that, read the Dodd-Frank Act and as it relates to swaps and the exclusive jurisdiction of the Commodity Futures Trading Commission. And I'm not an expert in preemption, and I feel like I'm along for the ride. Meanwhile, I continue to wonder, though, who really is protecting consumers from manipulated markets in this area. And that to me is a valid concern. And I think we're going to continue to see, coming back to your question about the press, continue to see press articles pointing out supposed manipulation of these markets. And I don't have any specific inside knowledge, no pun intended, on this matter, but I think the issue is going to be with us for a while.
Yeah, I think
I
you're
think,
exactly right. Protect the consumers. And I guess my point is no matter what the language is and what the Supreme Court decides, it still is the authority of Congress and the state legislatures. And it just does not make sense to allow this sports gambling outside of the regulation of sports gambling. Vin, I think you were going to go ahead.
Yeah, I was just going to say that I think that the creative lawyers at DOJ and the FTC and the state AG's offices know the statutes that are potentially being violated and will use insider trading and competition and all of those kinds of things as these matters work their way up. I'm sure that they are looking at them. So it's too early to sort of predict what's going to happen, but I do think that there are already a number of different statutes and regulations that can be looked at and will be and are being looked at in that space, Dan.
Agreed. And correct me if I'm wrong, but when you have this kind of legal uncertainty and this many court cases going forward, it just creates a vacuum of who's really in charge and who's supposed to do what. And until that's sorted out, I just have some questions about who falls through the gap of consumer protection. And remind me that I said that, as I said, 2 years from now, maybe everything will work out fine, but that's my concern.
Well, we should certainly come back in 2 years and take stock of where we are then.
Yeah, I would just say, Dan, the odds are that the concerns will be greater in 2 years than yours today.
So here's a question for all of you, because all of you have done work that touches on consumer protection and investor protection and corporate misconduct, or at least helping prevent it for decades. Is there anything different about the moment we find ourselves in terms of vulnerabilities, in terms of resources or approaches to assist consumers and investors? Is there anything different right now, or is it just part of a natural ebb and flow of resources and priorities?
I think there's increasing vulnerabilities because there's more and more money at stake. More and more money is moving around. And also with technology, it's much easier to reach people, a lot more people, and a lot more effectively. And I think the big change may be, your opening when you described how the new administration has moved to de-emphasize protection and enforcing the law. If they really move in a direction of deregulations and non-enforcement, that's makes people very, very vulnerable for the reasons I described. So much money at stake, so much abuse. I would just observe one thing that I think is really important and happening in this context. with the state AGs and antitrust enforcement. The antitrust enforcement has been a shared responsibility for a long time, but it's a case where the feds have been the big brother. They've had more resources, and frankly, they had a lot more credibility with the courts for a variety of reasons. But that may be changing now. And what we're seeing is that with the feds, there's questions about enforcement, there's questions about improper influence, particularly in the antitrust area. And that may be undermining the enormous credibility that the DOJ had, particularly vis-a-vis the states. And since that's going on, and what we're seeing is sort of that right in front of us with the Live Nation decision where Feds settled it and the states went ahead and tried it. We're seeing it in the Next Star situation. The states have achieved a great victory. New Mexico has in the Facebook case. So the states are moving into that area, but moving into the credibility to some extent of the feds, as the feds are sort of, I think, giving up some of that credibility. The states are picking it up where they were really the very junior member in terms of credibility in the federal courts on antitrust. And also coupled with that, I have to give a lot of credit to Phil Weiser, who's the Attorney General of Colorado. He really was the first truly antitrust lawyer to be AG and put a lot of effort, a lot of resources into it and raised the resources that the states had. The two major obstacles were resources and credibility with the federal courts. And then those are both sort of, I think, being taken care of. So we may be entering in, at least for a period of time, a new era of the importance of state antitrust enforcement. And I think it's real important to keep an eye on that.
Yeah, let me jump in and agree with you, Tom, on the state side. But let me take Adam's question from the perspective of a company, because I look at it as risk takers. With more lax enforcement, people are willing to take more risks and do things that are not necessarily appropriate, right? And that is something that, again, whatever your risk tolerance is as a company is movable. It might be, let's take this risk today, but there might be consequences, not necessarily today or tomorrow, but in 3 years, there might be consequences to the risk that you took. And so I think that focusing or changing priorities may let people think, oh, I can get away with these kinds of things now that perhaps I couldn't under a previous administration. I don't think that's the case. Risk is very dangerous when you don't have some measures of control internally. Some people watching what's going on in terms of those risk takers, like a good compliance officer who's saying we shouldn't be doing these kinds of things because it's either unethical or it violates a statute somewhere. But I think that from the perspective of a company, that's what they think about nowadays is, Adam, in answering your question, do I put my resources towards compliance or do I put it towards developing new markets where I shouldn't really be in? And so I think risk is also a factor from the corporate side of things.
Can I add one thing just to tee off on that? I agree with you, Vin, completely. And the Association of Certified Fraud Examiners recently published a report on sort of the frontiers of fraud and what companies and government officials ought to be concerned about. And they identified two areas that will sound familiar to all of us. It's cryptocurrency and digital fraud and scams, AI scams. That's not new. What was new was when they did their survey, and I downloaded it before this webinar, was they asked a question among anti-fraud professionals about what are your organizations moderately prepared to detect and prevent, for example, AI-fueled frauds? And the answer of people saying yes was very, very low. I think it was like 7% said that their organizations, public or private, were prepared. And so I think that illustrates Vin's point of not only the risks, but the effort that companies and governments are going to need to protect themselves and avoid both problems, legal problems, but also reputational risk problems. And I think that's something for us to keep in mind.
So Dan and Vin in particular, in your work over the last couple of years, have you seen any actual shifts in corporate risk taking or compliance efforts? Vin, I understand very much what you're saying about the risk analysis may be different, and everyone is focused on that and thinking about that. You don't need to name any names, but have you seen an actual difference in corporate decision making in the current risk environment?
Oh, yeah, I think it's real. Am I going to point to a particular company that's taking risks? No. Do we know who they are? Yes. So it's very real. And again, if they think nobody's looking, then they're going to do what they can to try to get away with as much and make as much money as they can. That's just the nature of human beings, right? And again, from Tom's experience, when you take a case as an attorney general and you make it the message and you send it out to everybody, like these kinds of cases we're going after. And so don't do that type of behavior. That makes a big difference. When that is not happening and the focus and the priorities are not in that area, well, when the cat's, away, that's what I think. Maybe a little bit cynical, but I think a lot of that's going on.
Adam, you've done a great job sort of moderating this, but in addition, you're in a premier firm that deals with these issues. What are your brilliant perspectives on some of the things we talked about? And have we gone off on the wrong trail a few times?
No, I don't think you have at all. From where I sit, just as a private litigator, I'm always looking at what the enforcement environment is for two reasons. One is in a more lax enforcement environment, we do see more private litigants just coming to us and saying, X happened to me. I was defrauded. I bought some crummy product. I have some grievance out there in the world, and the guardrails weren't there to prevent it in the ways that there should have been. And so I'm always thinking about that. And I'm always just thinking about our clients and the harms that they suffer and what are actually going to be the most effective and the most efficient and the most direct ways to protect them, right? I mean, a less scrupulous lawyer might be sitting there saying, well, what are the opportunities for me, right? Lots of fraud is great for business because there's going to be lots of people out there with claims to pursue. That's not always what I'm thinking about. What I'm thinking about is, I have clients, I care for them, they have real issues, and why aren't the entities that have the most visibility into emerging problems and abuses in corporate America not playing the role that they could be in terms of consumer protection and investor protection? And sure, there's interesting legal questions about the role of the feds versus the states. There's interesting questions about what is a security and where does the regulatory power of the SEC end and the CFTC begin. But at the end of the day, we have clients coming to us who are just trying to understand, how did someone do this to me, and whether that's an individual or a company or what have you. But look, as just also a human being in this world, I am very much looking forward to states having a more beefed up role, because I think they are pretty well situated to be more responsive to their constituents. And hopefully that's in coordination with the feds as well. But even if not, it's good to know that there's a more steadfast bulwark against abuse and fraud out there. I want to give each of you just a chance as we're wrapping up this discussion to leave us with some parting thoughts. First, thank you all, Tom, Vin, and Dan, for joining us for this discussion. It's really been engaging, and I'm very much looking forward to 2 years from now coming back and seeing where we are, and hopefully not in too much of a worse place than we are right now. But I just wanted to give you each 2 or 3 sentences to give some high-level thoughts about what are the challenges we're facing at the moment and what does the road ahead look like.
Well, I'd just like to underline what I said before about the states and antitrust enforcement, the credibility that they're picking up as the feds lose some credibility, and the resources that Phil Weiser and others have developed make the state AGs a very important place for antitrust enforcement. And equally so on the consumer side. In fact, more so on the consumer side, because there's more at stake. And I think the thing there is to watch the Meta, Facebook, Instagram litigation. New Mexico has already won that case. A private party has already won a case. What Facebook did is far worse, in my opinion, than the other technology companies in terms of hooking people and the effect on kids. That's just an amazing problem and an egregious wrong. And the states have already won one of those cases. And they're unlikely to lose all the other cases. They're going to win cases. And that's going to be a major, major development and perhaps major reform.
For me, a couple of thoughts. One is there are a lot of people looking at you, as a company. There are. Eyes are on you now. There's a lot more scrutiny with government dollars going out, with a lot more focus on fraud, false claims, waste, abuse. You have to keep your eyes and ears open and be aware that people are watching. That's number one. Number two, it goes back to what I was talking about in terms of risk. You need to understand your own risk tolerance and maybe have a risk assessment of your company done by a third party just to see what your risk tolerance is, and do your best to reduce the risk of something bad happening by putting mitigating efforts in place, so that when somebody comes to knock in, the feds, the state, a city, a private entity comes knocking, you're able to withstand scrutiny. One more thing that we really didn't touch on, but I wanted to mention it. The public construction world right now is under a lot of scrutiny because there's a lot more dollars going out in the public construction arena. And one of the things that's going on with the new Gateway project in New York, if it's on, if it's off, is they're putting monitors in place at the beginning of that process as the work is beginning. Very rarely happened before. And that type of scrutiny can save a lot of money and heartache when you look at things up front. And so it just, again, goes to the eyes and watching the dollars that are being spent by government agencies.
Well, it's a tough act to follow, but in addition to the things that both Tom and Vince said, I would just add the importance of the new technologies in crypto and AI and the opportunities they offer to change our lives for the better, but also the opportunities they can unfortunately offer for fraudsters and others who want to manipulate the system. And I think this is a really interesting and challenging time to be in this field. And as you said, well, Adam, there's a very important role for state AGs in this process.
Well, thank you all again very much. This has been great. I look forward to talking to you next time, and I hope everyone has a good day.